Welcome to our presentation on serving our most vulnerable youth. These are students that are experiencing homelessness and also youth in care. We have three presenters today. Vicki Hodges, she's a principal consultant with ISB, Chevelle Bailey with DCFS, and Kate Ulmer with foster care with ISB. I'm going to hand this over to Vicki. Vicki, if you can start telling us about homeless. Thank you.
Thank you. The McKinney-Vento Act was originally passed in 1987 and was reauthorized and signed by President Obama in December of 2015. Our Every Student Succeeds Act state plan was approved at the end of August in 2017. McKinney-Vento portion of the ESSA plan can be found on our website. The Every Student Succeeds Act removed foster care from under McKinney-Vento. The focus of McKinney-Vento Act is to remove any and all barriers to homeless children and youth education. Children of all ages face many challenges. At this time, the pandemic has most likely increased many of those challenges that children face. Lack of structure, routine, and stability, trauma in their lives, loss of housing, a family member, lack of stability in their lives, lack of access to food, lack of health care, adolescent mothers, inappropriate living conditions, such as no play space, living in overcrowdedness, unhealthy living conditions, the lack of structure, routine, stability, or over or under stimulation, stressed attachment to the caregivers, and invisibility that they may be invisible in the community. Illinois is a regional state, meaning that ISB receives funding from the federal government, and a portion of the funding is subgranted out to 7 areas of the state. Area 7 being Chicago Public Schools, and the other 6 areas are regional offices of education. The name and contact information for the lead area liaison for each of the areas is located on this map. Once the areas are awarded funding through the RFP process, the awardee then subgrants out to either ROEs or ISCs or school districts in their area. The subgrantees can be contacted to assist with serving homeless children and youth. Under the Every Student Succeeds Act, it is now a requirement that our lead area liaisons help identify preschool-aged and younger children living in the homeless situations and find programs that they may need for early childhood services. This is the preschool data for homeless students. We are hoping that they are being identified and served, but when we see the low numbers, we are concerned that homeless preschool children are not being identified and served. It's very important that if you have a family that meets the McKinney-Vento definition of homelessness, that they are entered into the student information system. The family does not need to accept services, nor do they need to confirm that they're homeless. Many families do not wish to be referred to as homeless, so you can use the definition as temporary living situations. It may come to a time when they do need services, so having them entered into the system will help with that. These are the most current pre-K through grade 12 student information system data that we have, which was pulled currently on February the 1st. FY18, we saw a significant increase in the number of homeless students enrolled in schools. At the end of FY20, we saw a significant decrease. The decline in data is most likely due to the COVID-19 crisis and schools providing remote learning. There are currently 34,025 students being identified. And we're pretty sure that it is much higher than that, and maybe when school resumes in session, we will see a change in that. McKinney-Vento definition: lacking a fixed, regular, and adequate nighttime residence, doubled up, which is the #1 living situation that we see today. Living in motels, hotels, trailer parks, not mobile home parks, campgrounds, all due to the adequate lack of accommodation. Living in emergency or transitional shelters, living in public or private place not designed for human living, living in cars, parks, abandoned buildings, substandard housing, bus, train stations, or similar settings. It can also be migrant families if they meet the above criteria. The NACI FAQ document now references substandard housing. The U.S. Department of Ed has determined that factors to consider in determining whether housing is substandard includes whether the housing lacks one of the fundamental utilities such as water, electricity, or heat, is infested with vermin or mold, lacks a functional part such as a working kitchen or bathroom, or may present unreasonable dangers to adults, children, or persons with disabilities. Unaccompanied youth is a child or youth who is not in the physical custody of a parent or guardian. Please consider if the child or youth's living arrangements meet the McKinney-Vento definition of homelessness. If the child or youth is not in the physical custody of the biological parent or guardian, there is no age requirement on an unaccompanied youth, so that can be a preschool child or it can be a 12th grader. What does fixed, regular, and adequate mean when it comes to determining homelessness? Is it fixed, stationary, permanent, or not subject to change? Could the child or family be asked to leave at any time? Is it regular? Is it used on a predictable, routine, consistent basis? Is it adequate, lawfully and reasonably sufficient? Sufficient for meeting physical and psychological needs typically met in a home environment. When making those determinations for eligibility, make it a case-by-case determination because not every situation is the same. At the bottom of the page is a link for a brief put out by the National Center for Homeless Education on determining eligibility. The brief includes sensitive questions that you can ask families to make those determinations. Where would you go if you couldn't stay there? What led you to move into this situation? Also, become familiar with McKinney-Vento definition and consider how the family scenario and the definition align. School stability. And how does school of origin assist homeless children? It provides one aspect of stability in their lives. They most likely do not have a stable living situation, so we can provide them with a stable educational environment. They have the right to continue in the school of origin for the duration of homelessness and until the end of the academic year in which they become permanently housed. McKinney-Vento and ESSA states that they have the right to remain in the school of origin if it is in the child's best interest. However, in Illinois, the parent and guardian makes the best interest determination. McKinney-Vento students are entitled to immediate enrollment in any schools that child living in the same attendance areas are able to attend. So, to the school of origin, the school where they last attended when permanently housed, McKinney-Vento eligible students do not have to provide required documents such as school records, immunizations, health records, proof of residency, guardianship, or any other required document. They must be immediately enrolled. Then the school district liaison will work with the family to get the needed documents. They must also be enrolled even if they have missed an application or enrollment deadline. Transportation. Many times, transportation is the #1 barrier to child's education. Transportation should be worked out immediately to prevent a delay in the child attending and fully participating in school. Early childhood programs. We do have state programs. This is a list of the early childhood programs that homeless children may access. When enrolling homeless children, ask if there are younger children in the family who also may need services. Preschool for All, Preschool Expansion, Prevention Initiative are all Illinois early childhood programs. They also may be entitled to Individuals with Disabilities Education Act. For Part B, infants and toddlers. For Part C, 3 to 5-year-olds. Child Care Development, Head Start and Early Head Start, and McPhee. So those are all programs that younger children may need to be able to be ready to attend school. The enrollment in preschool. Please reach out to your lead area liaisons for assistance. They will be able to help you make sure that they meet the definition and that they find programs in their regions which will be able to fulfill those requirements. Preschools are included in the school of origin definition. So if they've attended one school, they're homeless, they may go back to that school of origin. Here's a list of the allowable uses for Title I Part A set-aside funds. All districts are required to have a Title I Part A set-aside. These are the available uses. Separate from that set-aside amount, just using Title I funds may be used for transportation back to the school of origin and for salary for the school district homeless liaison. Support for success. At this time, we need to be thinking about how we can assist these children to make sure they're getting the best education available. And during this pandemic, we know that's been very stressful for families and for children, for teachers, for school districts, and for all of us. And we ask that you please, please, please support these children. At this time, I'm going to turn it over to Kate and Chevelle to talk about foster care. Thank you.
Hi, this is Kate from the State Board of Education. On December 10th, 2015, Obama signed into the ESSA Act, reauthorizing the Elementary and Secondary Education Act of 1965. It included significant amendments to Title I Part A, and implementation of these provisions is not part of the McKinney-Vento Act. Although there are some similarities between how McKinney-Vento provides services for their students, it is a little different. ESSA is also amended the McKinney-Vento Act to remove youth that are awaiting foster care placement from the definition of homeless. The phrase awaiting foster care placement, as I just said, was removed. They must be served under ESSA. Some children in foster care may still be eligible for McKinney-Vento services. Example, youth who are living in transitional shelters or motels. There is more information on the link that is provided below. There are many challenges that are faced by youth in care. I'm going to let Chevelle from DCFS go through some of these challenges. Chevelle?
Thank you, Kate. Challenges that are faced by youth in care include instability, placement disruptions, trauma, all things we can expect for youth that are involved in the child welfare system. And trauma has an impact on the children and their classroom behavior. These are all things that we should know. There's also stigma associated with being a youth in care or being involved in the child welfare system. So this is another challenge for youth. And then numerous appointments of case managers and changes the youth educational setting, inability to be in the same place for an extended period of time. These are all challenges that are faced by youth in care. So the other thing that is of note is the graduation rates for youth that are in care as compared to the graduation rates for youth that are not in substitute care. As you can see, that the graduation rates are on a slight incline in the past several years and have continued to go up for 2018, 2019, and 2019 and 2020, and we're currently at about a 52% graduation rate for youth that are in care. So youth in care, similar to homeless youth, have the right to remain in their school of origin unless it's determined that it is not in their best interest. Due to the high mobility rate of youth in care, all efforts need to be made to keep foster care youth in their school of origin. And so it's really important that we consider this when there is notification of a placement change, that we must do everything possible, and all efforts from all parties should be to try and keep that youth in their school of origin, if it's in their best interest. If it is not in their best interest to remain in their school of origin, then the child must be immediately enrolled in their new school, even if they don't have all of the required documentation. As you can see, these are very similar to the rights that are afforded to homeless youth. So when we're talking about a bid meeting or best interest determination meeting, it's different from a transportation plan. The best interest determination meeting is a child-centered meeting and should be focused on what is going to be the best interest for this youth as far as educational stability. Decisions need to be made on a case-by-case basis, and the cost of transportation should not be part of the consideration.
So a lot of people, my LEAs, which are my local education liaisons, will reach out and ask, well, what is this bid? What should it look like? So I have a quick diagram here to help you visualize this. So you add a table, or could be a phone conference, in person, however it is we need to do in these days of COVID, possibly over Skype or something like that. You have your participants from the local school. We have our foster care point of contact. We have school administrators. At some point, we need to pull in the transportation coordinator and possibly special education, IEP team. But who else should be there? Well, we need a child welfare representative. And I will let Chevelle talk about who that would be when we're talking about their child welfare representative.
The child welfare representative can be the case manager that is assigned to the family case. The child welfare representative could be someone from the Department of Children and Family Services Guardian's Office, or the child welfare representative could be the foster parent or fictive kin that is that the youth is in the care of. And so all of these people should be considered when discussing any best interest for the child.
And when you have the meeting, request input from school counselors, teachers, coaches. If the student is an English learner, the staff from your English learner department. And that's where we also have, there's a possibility the child's parents are still involved, so they may need to be at least contacted to find out if they have any input on this. Keep records. So this meeting, we need a record of this meeting happening. Local education agencies are required to keep records of these best interest determinations. All the reviewed information should be notated and or included within the record. Participants in the bid process should be included on that report. There is a checklist for the best interest determination meeting, and it is going to be available on our website under foster care. And that checklist has places for all of the things that were considered and discussed during this meeting. So you would need to keep that in your records. What bid factors should be considered? So when we're looking at the best interest determination for the student, something that you would not know, but you would need to find out is, how long is this placement expected to last? What is the permanency goal or plan? How many schools has this child attended in the past year? Are they a strong academic child? Or are they having a hard time in school? There's a lot of different things in here that you would consider. Now, the one I will point out on here is, how would the length of commute impact the child? So we're not talking about the money of transportation here. We're talking about the length of the commute. If it is 5 miles from your school as the school of origin, that is not the same thing as a 50-mile drive, especially if we're talking about the Chicagoland area. That would take a lot longer than 50 minutes to drive 50 miles. So you have to think, what is in the best interest of this child in all of these realms? Again, not talking about the payment of transportation, just the length of transportation, and if this child is able to handle something like that.
Other things that should be considered during the best interest determination meeting is how records will be transferred. There should be the transfer of records, if it is determined that it's not in the child's best interest to remain at their school of origin, should happen quickly. Both the child welfare agency and the LEAs must provide immediate and appropriate enrollment into a new school with all of the educational records of the child being provided to the new school. And this must happen as quickly as possible so as to reduce the amount of time that the youth spends out of enrollment. The bid meeting must be held before any foster care students move to a new school. So it's important that even if it is determined, at the last minute that a child must change placements, all efforts must be used to maintain that student's current enrollment until a best interest determination meeting can be held and it's determined that that is not in that youth's best interest. So the student must continue at the school of origin until an official determination has been made and all parties are informed. It would be appropriate at this time, if it is determined, if it was already known that, for instance, distance is going to be a significant factor and the new placement is very far from the current placement, it would be a good idea to include the new school as part of the best interest determination so that they get information regarding the youth, and a discussion about the transfer records can be had very early on.
The school may not prevent a foster care student from enrolling in a public school if they're lacking records. Getting those records transferred as quickly as possible. We would like it done within 3 to 5 days. This is something that the point of contact at the school should be coordinating, making sure that that process happens. Even if there isn't a history of placement in special ed, history of disciplinary action, behavior, fines, fees, health conditions, there is an immediate enrollment for the student. And right here we have where in ESSA, it says we need to receive them within 2 days. So I should amend that, not 3 days, as I said, but in 2 days after receiving that transfer request. A youth in care must be enrolled in the school not longer than 3 days following their placement. So even though it says in ESSA right there, 2 days, we want it done within 3 though. Well, so you have this foster care plan. You do have it in Iowa's under your foster care plan in the CDP, the Consolidated District Plan. So all staff certified, non-certified. So the secretary, the janitor, the teachers, all of them need to be informed about the foster care plan process. Think about how you're going to inform them of this. But what do I mean by the process? Do I need to tell them all the details that we go into? No. What they need to know is if they find out that a child is in foster care, has been placed in foster care, or there's an issue with that, they need to know who to contact within the school. And that person is someone that can get the process rolling so that if a best interest determination meeting needs to be made, it can be made as soon as possible. And you're not waiting for the child welfare agency to reach out and say, hey, there was a placement change. So we want this to be initiated as soon as one becomes aware of the student that is eligible for services. Chevelle?
Thank you. So for the DCFS Normalcy Act provides that every child in DCFS care be considered a normal child, although they are in substitute care. Often children in substitute care want and have needs to experience normal childhood experiences and normal activities, things like sleepovers with friends or going on vacation or playing on sports team. DCFS authorizes all caregivers for youth in care and out-of-home placements to use the normalcy parenting and the reasonable and prudent parent standard to give or withhold permission for age-appropriate enrichment, extracurricular, and social activities. So the foster parents or relative care providers are able to give permission for those activities as it relates to school participation. The Normalcy Act differentiates, allows for some differentiation of where you would need to have a formal approval from the DCFS Guardian's Office, or where a foster parent would be able to provide that approval. And here we can see for things like athletic participation and extracurricular or recreational activities, certainly the foster parent is of giving permission for the youth to participate. When it comes to behavioral mental health services for a child or youth in care that's under the age of 18, that's when you would need to seek the permission of the DCFS Guardian's Office or an authorized agent for those youth. And then youth ages 12 to 18 must also consent to release of their mental health information. When it comes to a driver's license permit, again, that's something that the foster parent can authorize. But if we're looking at things like media requests or release forms or requests to interview youth in care or release of any sort of liability, again, the DCFS guardian or authorized agent. And then routine activities like field trips or school enrollment, even report cards, again, extracurricular activity, including athletic participation, school photos, yearbook pictures, social media contacts, travel with the caregiver in state or out state, or travel more than 4. Those are all things that the foster parent, can authorize. And then finally, with regard to school suspension or expulsion notices or any travel out of state for 30 days or more, you would need the authorization of the DCFS Guardian's Office.
So what funds are there for the youth in care? Foster care is categorically eligible for Title I Part A services, whether or not they live in a Title I Part A school attendance area, whether or not they attend a Title I school or they meet the academic standards required of other children for eligibility. If an LEA offers a public preschool education, the LEA must meet the Title I requirements for children in foster care in preschool, including ensuring that a child in foster care remains in his or her preschool of origin, unless a determination is made again, that it is not in the child's best interest. So a bid meeting. Transportation. So now we get down to the transportation and the money of where that comes from. So ESSA amended the Title I Part A of the Elementary and Secondary Education Act, requiring that LEAs receiving Title I-A funds collaborate with state or local welfare agencies on local procedures for transportation for students in foster care. This must be accomplished by ensuring that transportation for children in foster care is provided, arranged, and funded. An LEA must ensure that transportation provided for children in foster care is consistent with the procedures developed by the LEA in collaboration with state or local welfare agency. These requirements apply whether or not the LEA already provides transportation for children who are not in foster care. So even if there's no transportation for the rest of the school, a foster care student is still eligible. An LEA must ensure that children in foster care needing transportation to the school of origin promptly receive such transportation in a cost-effective manner. The LEA must provide or arrange for adequate and appropriate transportation to and from the school of origin while any disputes are being resolved. To the extent that the charter school is considered an LEA under a state's charter school law, it must meet the transportation requirements on the same basis as any other LEA. The plans, you are to develop and implement clear written procedures for how transportation will be provided, arranged, and funded for the duration of time students are in foster care. Your funding is located in your CDP in Iowa's Consolidated District Plan. Ensure that students in foster care will promptly receive this transportation in a cost-effective manner, and ensure that if there are additional costs incurred providing transportation, the LEA will provide the transportation. If the local child welfare agency agrees to reimburse the LEA for such cost of transportation, that is one option. The LEA agrees to pay for the cost of such transportation, or there's a possibility that the LEA and the CWA, Child Welfare Agency, agree to share such a cost for transportation. There is additional information on the website listed below. There is currently an agreement between DCFS and ISB for transportation. Chevelle, would you like to discuss that before I move on to the next page?
The agreement between DCFS and ISB allows for the LEAs to provide transportation for youth in care so that it is immediate and reduces the amount of time that a youth would spend out of school to maintain enrollment at their school of origin. And then the Child Welfare Agency, or DCFS in this case, then reimburses ISB for 50% of those transportation costs. So that is why it should never be a limiting factor in Illinois that a youth is provided transportation, because there is already a solid agreement in place between ISB and DCFS to allow for the funding of such transportation.
Well, what happens if a child is adopted or they leave foster care? Should they stay in that school of origin? Well, these requirements that we've been discussing no longer apply to a student once they have exited foster care. However, we encourage you to prioritize educational stability for these children. Well, why? Because they benefit academically from a school continuity during times of transitioning out of foster care. That way they can maintain connections with their peers, teachers, and other supportive adults at school. A child that exited foster care during the school year can continue in the school of origin throughout at least the end of the academic year if appropriate. However, transportation is not required to be provided if the student resides outside of the school of origin district boundaries. I believe that will conclude our presentation on foster care and homeless students. Please look for additional information on our website for both homeless and foster care. DCFS also has a website. Feel free to email us with any questions that we have not answered. We have Vicki for homeless, Kate for foster care, and Chevelle with DCFS also for foster care. Thank you for joining us, and I hope you have a great day.